Milord, what is Milord ED's anxiety today? Because he has not been arrested in connection with any ED case.
Yes.
But today, my lord, the custody becomes illegal. Today, the custody of the police, as far as the accused is concerned, is illegal because it's contrary to a judgment of this honorable order of this honorable court. So that illegal custody has to be rectified, and the only rectification is if by handing over the custody to CBI.
The main purpose is this, and not only in this case, I have an experience as ASG. In all the cases where CBI was appointed by the Honorable Court, there is desperate attempt to frustrate the proceeding on the ground of pendency of SLP. Now comes the moot question whether pendency of an SLP is a stay. Is not, number one. Number two is that even if SLP is filed, which is mentioned today, their lordships refuse to give any peremptory hearing or an urgent hearing, refused to issue notice, and directed that it shall be listed in due course.
Petitioner, my lord, at whose behest the application for contempt has been filed. My lord, the order
Milord,
passed.
I appeal, Milord, for the alleged contemners. Now, Milord, we have moved the Honorable Supreme Court against the order. Yesterday, the matter was mentioned before the bench, which is.
What is the order? I am not aware of.
My lord,
Let us have the facts.
Right.
I am not aware.
My lord, may I be permitted to state the facts, my lords?
Yes.
I am appearing for the ED, my lord, at the moment, my lord. Kindly have a look, my lord.
You are appearing for whom?
Enforcement, the applicant, as far as the contempt application is concerned.
You have filed a contempt application.
my lord.
Yes, my lords. Yes.
What is the first thing is what is the order?
Yes, my lord. I'm
You
aware.
allege that has been violated.
Yes, kindly have, that is apparently violated, my lord. Kindly have a look at page number 41, my lord, the operative portion of the order, page 41, paragraph number 18.
Can you give me just 30 seconds time to go through the order?
Very well, my lord.
Just wait. My brother was a party to a order. I am not. So
I can understand, my lord, side.
yes, 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 Mr. ASG.
My lords, I may just point out, my lord, the incident happened in this manner. The ED was investigating a ration scam case pursuant to an FIR, and they went to search the house of the main accused, that is Shah Jahan. And when they went there, along with the CRPF team, they were badly assaulted. Door was not opened. Search was not allowed to be conducted. 3 officers of the ED were injured. 1 was seriously. Therefore, we gave an application to file a complaint to the police. The ED officers could only escape because we called the local police. The local police came there and escorted us. The mob was sort of attempted to be pacified. This is how the ED officers escaped, otherwise they would have been killed. This is one, my lord. Therefore, we gave an application, a written application pointing out the incident to the local police. The local police tried to scale down the incident, got another FIR filed by a policeman so that it is watered down. That is one. That is FIR 8. Our FIR became FIR 9. And a false complaint was filed alleging making baseless allegations of ED officers. That has been stayed by another bench. It's not the subject matter of the present petition. When we found that the relevant sections, important sections, have not been incorporated and that the investigation is conducted in a biased manner trying to protect the accused, we moved this honorable court asking for a CBI investigation. The learned judge who heard the matter accepted our contention and said that the need for CBI investigation is warranted. But CBI investigation was not granted, saying that you have not filed for transfer of the predicate offense, which has nothing to do with the incident of assault. So, and therefore we challenged that order, saying that then the learned judge constituted SIT, comprising 50% of the Calcutta police and 50% CBI.
50.
Yes, 50%, half, my lords.
50, 100.
Yeah, 50, half to be from Calcutta police, half to be from
Means
CBI.
25.
Yes, 25, whatever it is. So we challenge this, saying that it would frustrate the investigation. You can't have 2 persons heading the investigation. So the division bench of this honorable court, my lord,
Now,
state that
what is the point? I have
state the order. The single judge already stated the investigation as far as the local police is concerned. Now, in the meantime, a suo motu petition was filed that the main accused, Shah Jahan, was involved in large number of cases, is not being arrested. So the division bench said you can arrest him. I pointed out to the division bench, there are 42 cases pending as the main accused. He should not be arrested in this case. And he can be arrested in the other cases. The division bench, my lords, permitted both the CBI, ED, and the police to arrest him. Now, in order to frustrate that investigation, the Calcutta police arrested him, my lords, on 29th of February 24, produced him before the magistrate on the same day, and obtained a remand till March.
Mr. ESG, I have gone through all these findings which is returned by the
Yes, sir.
division bench. The only thing is that ultimately the division bench was of the view that it's a fit case where it should be investigated by the Central Bureau of
Yes,
Investigation.
sir. That's by right, my lords are right.
Yes, and then directed this particular the person to be forthwith handed over to the CBI.
Yes,
Time limit was already given there.
yes.
Now, what is your grievance? Now, what is
Now,
your
I'll tell my lords what my grievance is. This order has not been complied with. This has been flouted.
they have not handed over
They have not handed over. They are on a pretext that we have moved to Supreme Court. And Supreme Court, yesterday it was mentioned the matter was not taken up. Today morning also it was mentioned matter is not taken up. So the matter is, yesterday they said we are going to file. Today they said we have filed. They also, therefore, my lords may kindly appreciate. There is no order staying this particular order which they have flouted. Now this order the forthwith was a requirement of necessity because your lordships are aware that custody of an accused to police custody is limited to the first initial 15 days. They were keeping that in mind. The division bench ordered, my lords, that he should be handed over forthwith. Now, because they are going to move a petition, they asked for stay of this order, which the division bench refused. Despite that, my lord, is a clear case of contempt. That the correspondence which is annexed, which is subsequent to this order, my lords may kindly appreciate. At pages 47 onwards, my lord, CBI has written to them intimating this. The state was represented by the Advocate General. He was present. It's not as if that they were aware of the order and they say we're going to file a petition. But even if you want to file, there is no stay. If there is no stay, it's a contempt. You cannot say no. We are going to file a petition, therefore we are not going to comply. That can't be, my lords. Kindly have a look at page 47, my lords. This is written by the CBI to the Deputy Inspector General.
They have said that the things they have already filed an SLP before the Supreme Court or a contempt thing to file.
Yes.
So it should wait.
Yes, it can't wait. If we wait, the order, the purpose is frustrated.
Yes.
The purpose is frustrated.
Let us hear the state.
My lord,
Yes.
before that, kindly hear me. I am appealing for CBI, who was directed to take custody of the accused and also to hand over the documents. Some documents are to be brought to your lordship's notice. Now, firstly, my lord, your lordships have seen the operative part of the order as 41. The next part is this letter of the CBI, head of branch. Kindly come to page 42.
Yes.
Kindly come to page
That's an email.
45. Yes, email. There are series of documents and communications. Page 42, the email. This is from head of the branch, CBI, communicating the order of the Honorable Court to all the officers of State of West Bengal who are alleged contemners here. Page 45.
Yes.
Then kindly come to page 43, once in the list, because this is also important. Page 43.
You say the certified copy of the FIR may be provided so
Exactly, my lord, towards the middle portion, please refer to the trailing email as desired by the head of branch. Certified copy of FIRs may be provided so that case can be processed
Yes.
as per the direction of the Honorable
I
Court.
have
Then
read it.
kindly come to page 44. These are series of communications to the alleged contemners at page 44B, letter to DGP, Chief Secretary, and the Najat PS and all others even including the additional Director General CID, these are communicated. Now then kindly come to page 45. These are blood communications, page 45. This is another letter
By hand it was
written, and it was by hand, sir, by the head of the branch CBI. That is, I should read the entire letter. Please find enclosed herewith copy of judgment passed by the Honorable High Court at Calcutta, such and such. Honorable High Court at Calcutta allowed the writ petition. This is the operative part. In pursuance of the above mentioned order, you are requested to hand over the above mentioned case records along with the accused to CBI team led by Sri Gaurav Singh, SP CBI, ACB Kolkata, along with investigation officers such and such, arising out of FIR number such and such. Now then, beloved, kindly come. This is next letters are very surprising.
No, before my learned friend proceeds to the next letter, kindly see the endorsement. It is received by him at 7:15 hours.
Yes.
5:50. 17.
17:15, that is 5:15.
Yes.
17:50.
Means 5:15
Yes.
PM.
Now, my lord, kindly come to page page 45.
46 or 45.
45 I have read out.
Yes.
Now kindly come to page 46. What is the letter written by the officer in charge of Najat police station? This is in CW above reference. This is to inform you that the entire case docket along with the all relevant documents, articles such and such, is lying here in Najat PS. Kindly depute one officer to collect the same from here from Najat PS. Then my lord, the next annexure. What is the letter written by Deputy Inspector General of Police CID?
CBI or
No.
CID.
CID.
Yes.
Now this letter has to be read in the entirety. In reply to the letter number CBI number such and such, this is to inform you that today on 5 March 2024, State of West Bengal has mentioned before the Honorable Supreme Court of India against the order dated such and such of the Honorable Court, Calcutta, in MAT number such and such. According to the learned AOR and Standing Council of Supreme Court of India, the filing of SLP has been already initiated and this is likely to be heard tomorrow morning. Hence, you are requested to wait till disposal of the special petition. What kind of a statement? You are requested to wait till disposal of the SLP. And this is no less from the Deputy Inspector General of Police CID. Had it been the case, wait till the interim order relief is obtained by us. Wait till the disposal of the SLP. Then we will not kindly come to the next one. This is a letter we wrote to the Director General of Police, intimating everything. Well, this is the concluding part is page 49. However, it is brought to your kind notice that the undersigned received WhatsApp call from such and such, Rajshekhar ADG CRD, West Bengal, through mobile number such and such, whereby he informed that he mentioning has been done against the order of the division bench in the Honorable Supreme Court, which is listed tomorrow. Hence, the custody cannot be given to the CBI at this stage. This is also a false statement. I shall show you what is false statement from the Supreme Court's website documents. Then, my lord, another one at page 50. This is written to the Chief Secretary. This is all by the CBI, who were granted custody not only of the accused but also of all the documents. This is to the Chief Secretary. Now your losses will be surprised to find what is the opinion given by the officer in charge. The next one at page 52. With reference to our earlier mail such and such, according to learned AOR, Standing Council Supreme Court, the filing of SLP has already been initiated and this is likely to be heard tomorrow morning. Hence, you are requested to wait till the disposal of this special petition. The officer in charge is saying, wait till disposal of the judicial proceeding is thwarted by writing such time and again such letters, when the no less, my lord, the Honorable the Chief Justice Division Bench of the Premier High Court passed an order considering the urgency and also the time limit frame and considering also section 167 CRPC that custody at best is available for 14 days from the date of arrest. The entire purpose is to frustrate the entire custody and interrogation by the CBI. আমার ফাইলগুলো কথা বলে এসএলপি গুলো সুপ্রিম কোর্টের কাগজগুলো Then again, my lord, kindly come another. What is the my lord, letter written by another officer in charge of the police station, page 53. The same thing,
The same line.
till disposal of the SLP. Now comes the moot question whether, my lord, the SLP was filed yesterday. Now the Supreme Court's from website we have got that SLP was not filed yesterday. It was filed at 1 a.m. yesterday at night,
In the midnight.
in the midnight. We should call it 1 a.m. because after 12. Now this your lordship will kindly find from the endorsement of the Supreme Court website. And this is, my lord, the diary number was given. Now kindly see what is the statement they have said that SLP is being filed and when it is filed. What is the main purpose? Is to frustrate the custodial interrogation under section 167 CRPC. The main purpose is this, and not only in this case, I have an experience as ASG in all the cases where CBI was appointed by the Honorable Court. There is desperate attempt to frustrate the proceeding on the ground of pendency of SLP. Now comes the moot question whether pendency of an SLP is a stay. Is not, number one. Number two is that even if SLP is filed, which is mentioned today, their lordships refuse to give any peremptory hearing or an urgent hearing, refuse to issue notice, and directed that it shall be listed in due course. Therefore, my lord, this is a case on the contempt, two aspects. One is for punishment and the other is for execution and consequential relief. So direct, my lord, them to hand over all documents by 2 o'clock today or 3 p.m. today, including the accused, and all other documents, otherwise the entire proceedings shall be frustrated. Section 167 CRPC subsection 2 clearly provides it is only 14 days custody can be obtained. And the entire purpose of interrogation and the judgment of the Honorable Division Bench presided by the Chief Justice will be frustrated. Therefore, your lordships are not powerless to direct them to hand over in execution of the order passed in contempt.
Madam, may I only point out one thing that I missed, my lord? Kindly have a look at order 17 of the Supreme Court rules.
Yes.
Madam, ask. Madam, order.
Is that we don't have the hard copy of those.
My lord, we will hand over on the tab. My lord will kindly allow us to produce it
No,
digitally.
I am always open for the any kind of a technical gadgets.
My lord,
Technology is
hold it
always
as, my lord, we are
accepted
handing over.
by me. No difficulty.
My lord, but here it is, my lord. I apologize, my lord, not being ready, my lord, but it is there, my lord. Just fine for my lord. 8 of the
Yes, Mr. SG, what do you want to refer to?
Kindly refer to order 17, rule 1.
Yes.
Miscellaneous, the title is miscellaneous.
Yes, hearing of an appeals.
And the file, just that is order 16. After that, miscellaneous, my lord, order 17.
Order
Miscellaneous.
7. Yes.
The filing of a special leave petition or an appeal. My lords have got it?
Yes, shall not prevent the execution.
Shall not prevent the execution of the decree or order appealed against, but the court may subject to such terms and condition may, if it thinks fit, impose order on a stay. So unless the Supreme Court passes an order, this decree or order has to be implemented. And this initial fit, the purpose is the police custody can be granted only in the initial 15 days. Chunk of the period is over. If they delay the proceeding, the 15 days will be over and the custody, we will not be able to obtain custody and proper investigation. Therefore, they want to make the order of this Honorable Court infructuous by adopting these delay tactics which should not be permitted.
Yes.
Therefore, this is a clear case of contempt, my lord.
My lord, only one.
And my lord may also appreciate, my lord, this honorable court has said forthwith. Otherwise, they would have, therefore, this honorable court was aware of the urgency of the matter.
And my lord, only one.
Even Mr. ASG, when
Yes.
this point arose, like Order 17, Rule 1 of the Supreme Court rules,
Yes.
there was a Malimat committee which was constituted in 1998
Yes.
or 1999.
Yes.
And the suggestion or the recommendation of that Malimat committee was that there should be an incorporation of these kind of words into a statute that is a processual law or a procedural law, 115 of the CPC, Order 41, Rule 5, where they indicated that mere filing an appeal shall not tantamount to stay of the execution
Yes.
of the order.
I'm obliged, my lord. I'm obliged, my lords. But anyway, my lord, as far as the present case is concerned, it's the Supreme Court and they have filed the SLP in the Supreme Court. Therefore, the rules of the Supreme Court are binding. There's no stay. Unless you get a stay, you cannot, it's like a self-goal. You cannot just say that I'm granting stay to
The
myself.
most fundamental principles, there is no difficulty in this regard.
There are only
Yes,
one more
let us-
point. One more point.
What
guys.
more?
One more. Yes.
But today, my lord, the custody becomes illegal. Today, the custody of the police, as far as the accused is concerned, is illegal because it's contrary to a judgment of this honorable order of this honorable court. So that illegal custody has to be rectified, and the only rectification is if by handing over the custody to CBI. Today, every minute the custody is illegal. The person is being detained illegally.
My lord, only one more
Let us
point.
see.
Only one more
Let us
point.
hear. Yes.
My lord, only one more point. Under the criminal jurisprudence, your lordships are aware, any kind of offence committed is an offence against society. And on perusal of the judgment delivered by the division bench, it appears is the gravest of gravest offence. Therefore, there is no question of mercy and it has to be handed over to the CBI.
Yes.
My lord, now we have got it on a tap. If my lord so desires, we can give them. We are also providing hard copies to my lord.
My lord, my learned friends, my lord, I have given your lordship, my lord, the developments, my lord, which had happened, my lord, post delivery of judgment yesterday. But I'll just, my lord, add to that. First is, my lord, yesterday, my lord, in the evening before the rising of the court, my lord, the court number 2 was, the matter was mentioned before the court number 2. The court number 2 said that you should mention it before the court number 1, which was then hearing a 9-judge bench matter. And, my lord, the court number 2 also, my lord, advised us that you please apply through the Secretary General of the Supreme Court so that the matter can be placed before the Honorable the Chief Justice. Then, my lord, we have accordingly done so. My lord, we have given a notice. Thereafter, my lord, the 287 pages SLP was prepared and it was filed at around 1:40 in the morning today. Thereafter, my lord, the matter was again mentioned, my lord, today before the division bench or the court number 2. Then with notice, my lord, the formalities, my lord, I don't know in details. And, my lord, with this an SOP, I am told. But as per the SOP, my lord, we had done whatever was required to be done. Now, today, my lord, when the matter was mentioned, the court number 2 said that since you have followed the SOP and you have sent an email, the matter will be placed before the CJI at lunch. Now, my lord, and my lord, our learned senior advocate, my lord, Dr. Singhvi, my lord, insisted that there should be at least some oral instruction or orders, to which the court obviously, my lord, did not, my lord, accept. Then, my lord, we had informed the judicial registrar who has taken the matter. And now, my lord, my latest information is that the file is in the chambers of the Chief Justice of India. My lord, our learned advocates, my lord, they are waiting outside the chamber of the learned Chief Justice of India, Honorable Chief Justice of India. But as soon as, my lord, his lordship, my lord, passes, my lord, appropriate directions, my lord, the matter can either be placed today or tomorrow. Now, this is the, my lord, the factual situation so far as, my lord, the filing of the SLP is concerned. Now, my lord, kindly consider one thing, my lord. Yesterday, my lord, the matter was, the order was passed around 2:30 or 2:45 p.m. Around 3 or whatever, in the second half. Therefore, my lord, the earliest that we could move is, my lord, to mention the matter before the Supreme Court yesterday itself before rising of the court. We have done so. Therefore, my lord, I was only praying this, my lord, your lordship may kindly, my lord, keep the matter tomorrow so that, my lord, we can at least find out, my lord, what is the direction of the Honorable the Chief Justice of India, and thereafter, my lord, we can come back before your lordship, my lord.
There appears to be some kind of a variance in the submission of both the learned ASG and you, the learned Advocate General,
Yes, ma'am.
because they have said that this matter was mentioned, and the court has said that I am not going to list the matter on an urgent basis.
no.
It will come in a usual course.
And
In a
no
usual-
stay was granted on oral mention.
The SLP was not filed, how can
and
stay be done?
This,
SLP
this
was
is
filed
what
yesterday.
this is what their version is. You are saying that yes, it was entertained. The direction was passed by the courtroom number 2
Yes.
to move it, to file it, to move before him. He directed the matter to be placed before the Honorable CJI.
Yes,
All these things appears to be a bit contradictory. Not contradictory, but in a variance.
my lord, I can.
So,
Yes.
so now,
My lord, may I just say one thing, my lord? Whatever order your lordship will be pleased to pass today, that will be subject to the decision of the SLP.
my
Why interim order, really? Where is the law that filing of an SLP is ipso facto grant of stay and mentioning will stall the proceeding and custodial trial?
It is where custodial integration is needed. In such a case, where custodial, right? Civil cases, it can be. Purpose is to frustrate the custodial integration. See, and then it had to, what would have accepted?
May I only mention this, my lords? But every minute there's a contempt because there's flouting of the orders. Every minute there's illegal custody. My lord, illegal custody cannot be perpetuated in this manner, my lords. And today I was present in the second court, my lord, virtually when the mentioning was made. The mentioning was, it was said that the matter is coming up before the registrar and then it will be placed before the Chief Justice. But there was no stay granted. There was nothing, and there was no order in favor of the other side, my lords. Therefore, there is no order obtained till today. They would have, it's many times orders have been passed in mentioning by the apex court. No order has been passed. It is only for the purpose of listing that the matter is there. It is not even for the purpose of stay. For the purpose of listing, order 17 is clear. It has to be implemented. And custody, which is illegal, which amounts to an offense, can't be allowed to be perpetuated in this manner.
But if my learned friends are finished, may I make some submissions?
But there can't be rejoinder to rejoinder, my lords. And that by a contemner, but he has to purge himself first of the contempt before he makes submission.
Mr. ASG, I think the learned Advocate General could not finish up.
Very well. Yes.
My lord, I have never submitted that, my lord, filing of an SLP amounts to grant of stay. That is never my submission. I have also not submitted that if an SLP is filed, your lordship's hands are tied. I have never said so. I have also not made any submission that the court has granted a stay orally. These are none of my submissions. Therefore, I do not know why these submissions are being made. Now, the point is, number one, my lord, I have a right to prefer an SLP. I am pursuing that right. Number one. Number two is, my lord, the shortest possible or with the maximum speed at which, my lord, work could be undertaken, my lord, we have done so. Now, my lord, there are certain procedural matters, my lord, which I cannot dispense with, my lord. I have to undergo those procedural matters, and my lord, in such fashion, my lord, there is some delay. I won't say at whose instance, my lord, that the matter could not have been taken up till now. But if the Honorable the Chief Justice feels that there is urgency in the matter, the Honorable Chief Justice of India may direct the matter to be listed today in the second half or sometimes tomorrow morning. Therefore, my lord, I request your lordships to, my lord, apply those principles where, my lord, the Supreme Court has said that filing of an SLP is not a grant of stay, but still, in appropriate case, my lord, the court may be slow in moving with the contempt petition. These principles are also there. I just only to remind your lordships. The moot question is, my lord, today, my lord, or at this moment, going by my instruction, my lord, the files are for the consideration of the Honorable Chief Justice of India. Therefore, my lord, kindly, my lord, post this matter as the first item tomorrow, so that, my lord, what development takes place today, my lord, we can come back before your lordship and inform your lordship. Number one. Number two, my lord, this tearing hurry which my learned friends have. But on that, my lord, may I only say this, my lord, 29th, my lord, we got remand. From 29th to 5th, that is yesterday, my lord, my learned friend's client did not move. If they could have waited for 6 days, but I think, my lord, they can wait for the 7th day also.
My lord, I had mentioned it before the Honorable Chief Justice.
Whatever.
No, my lord. I am a testimony to entire affairs that had happened before this Honorable. I mentioned it.
My lord, this
No, my
does
lord,
not go with
submission
the tradition of our court.
My lord, I apologize, my lord, render unqualified
So
apology.
after I finish, you say that I have placed untruth matters before the court, but not intervening in course of submissions. Well, what my learned friend had taken steps is one thing. Definitely nobody says that they have not taken any steps. What I have said is from 29th to 5th, if, my lord, matters could wait, well, in my very humble submission, matter can wait for a few more hours. And the last is that they are saying, my lord, that after 15 days police remand, they cannot get it. But I am not here to advise them. The learned ASGs are there to advise them whether thereafter it is possible or not. Yes, sir.
My lord, if my learned friend has finished, may I point out, my lord?
Let us ascertain. Have you
Yes.
finished?
Yes, my lord. So, my lord, I very respectfully submit, my lord. Kindly, my lord, take up the matter tomorrow at the first item, so that, my lord, we can come back before the court and, my lord, inform your lordship what has happened. Or, my lord, if your lordship may take it up, say, after a few hours, my lord, maybe at 4 o'clock, we can come back and inform your lordship.
Yes.
My lords, may kindly have a look. What is this request, my lord? The request of the learned AG is that keep the matter tomorrow because my matter is going to be listed tomorrow. That is on an assumption and a presumption that the matter is going to be listed. There is no guarantee that the matter will be listed tomorrow. In the meantime, the period of 15 days he has been remanded till the 10th. Till the 10th. 10th we are approaching. If that doesn't list, if the matter is not listed tomorrow, he'll come back tomorrow and say matter is not listed. Post it day after tomorrow, Saturday and Friday, Saturday, Sunday are holidays before the Supreme Court. So he'll say matter is not listed. Therefore, this will go on, my lord, till the entire thing is frustrated. Now, if my lords may kindly have a look at, my learned friend wanted us to give advice. The advice is covered by judgment of the Supreme Court in Kulkarni's case, my lord, where their lordships have held that the police custody can be initial 15 days. Though it is doubted in a subsequent judgment, is referred to a larger bench. But the law as it stands today is that we can get custody for the first 15 days. He was arrested, my lords may kindly have a look, on 29th and remanded on 29th. 15 days, the court has granted him 10 days remand. The court may not grant further remand. So during these 10 days, we have to take custody and we have to examine and we have to find out certain details. That is obviously not being allowed. Therefore, this tactic of getting the matter adjourned is only for the purpose to see that we don't get custody of an accused who's involved in large number of cases, 42 cases, but we are not concerned with that. But in our case, he's been involved, so that as far as we are concerned, the CBI is concerned, CBI doesn't get custody. But then, my lords, may kindly have a look at his next submission is wait for few more. There is no guarantee that we have to wait for few hours. Few hours also the matter will not be listed. He doesn't say that the matter is not listed by few hours, your lordship may pass appropriate order. He says go on indefinitely adjourning the proceeding till the matter is listed. But therefore, the entire purpose is oblique, it's not a genuine purpose, especially in the background of the fact that this Honorable Court had refused to grant stay of the order.
Yes.
And my lord,
May I just say one
Has he
sentence?
finished? Your counterpart,
Yes.
yes.
ASG, both of you are ASG. That's why I
Very well,
asked.
very well.
Whether your
Only one
counterpart has-
sentence.
Yes, ma'am.
So, yes.
Milord, one sentence. The Learned Advocate General has submitted that the accused was arrested, taken to custody, state custody on 29th, and what we are doing. The judgment is delivered yesterday. For CBI custody.
No, it was moved yesterday.
No. The judgment was delivered yesterday for CBI custody by the division bench. So there's no question of an argument that what we are doing since 29.
And there's one more thing, Malad, I forgot. I'm sorry, Malad. I'm sorry about this. Before passing of this order, the court said even CBI can arrest. That order has not been protested against.
The
That's
enforcement.
all. That's all.
Yes, that's all.
Yes, Malad. I'm grateful, Malad.
I understand, Millard, that in a contempt proceeding there is the requirement of an informant. That I understand. That ED is in the position of an informant before this court, that a contempt has been committed. But, Millard, the person or the CBI to whom, Millard, the custody has been directed is not before the court with any complaint. It is the ED who is before the court, number one. And number two is, Millard, what is, Millard, ED's anxiety today? Because he has not been arrested in connection with any ED case. What is the ED's anxiety today?
The subject matter
So this is not Millard, this is not in
As you correctly, even a court, there is
Yes,
no
doubt about it. No doubt
impediment
about
to the court to initiate a suo moto
Right,
proceedings for that.
No doubt about that.
So
No
contempt
doubt about that.
proceedings only is an informant.
Right.
We have to go whether the
Yes.
orders have been flouted, orders have been violated.
Yes.
These are the basic thing
Right.
the court
Right.
has to consider.
Right.
So
Now,
see,
so far as the ED
what
is
is
concerned,
your latest report?
Millard, the latest report is, Millard, my advocate on record is still waiting, Millard, outside the courtroom of the chambers of the Chief Justice of India. But she has told me that as soon as I get the information, I'll get back to you. Therefore, Millard, kindly keep it, Millard, as the first matter tomorrow.
No, it can't be tomorrow.
Sir, I have been I can to circumvent the proceedings. Circumvent the proceedings. Circumvent the proceedings.
Lord, in reply, may I say again another sentence?
Not more.
One sentence. On perusal of the documents of the officer in charge and the others, it is civil and criminal contempt both, interference with the administration of justice. Therefore, your lordships rightly fell from your lordships that suo motu cognizance can be taken in a criminal contempt. The letters written pursuant to the Honorable Division Bench order presided over by the Premier High Court Chief Justice, by an officer in charge of a police station, to circumvent the order.
My lords, we have got a copy of Kulkarni's case, Millard. If my lord so deems fit and proper, we can hand over that judgment.
We are concerned with the implementation of the direction passed in the order dated 5/3/2024. considering the gravity of the gravity and the seriousness of the facts discerned in course of the disposal of the said proceeding, the division bench was of the view that the custody of the accused, namely Shah Jahan, should immediately be handed over to the CBI, and even proceeded to fix a time within which such custody is to be handed over. Such being the nature of the direction, we do not find any fetter or impediment on our part in not directing the implementation of the said order pending the contempt application, despite the fact that a special petition is pending before the Supreme Court. But the fact remains there is no interim order of stay of the operation of the said order passed as of this time. Since an opportunity is required to be given to the LS contemners to deal with the allegations contained in the instant contempt application, we therefore direct the LS contemners to file affidavit of opposition to the contempt application within 2 weeks from date. Reply, if any, shall be filed within a week thereafter. Stop. The next paragraph. The LS contemners are directed to immediately implement the order or the judgment passed on 5/3/2024 by 4:30 today. When 4:30 today, full stop. Yes, anything more?
Grateful, my lords.
Can it be made 4? Then if it is again not implemented, we can come back before my lord at 4:30. Because I have my doubts. My lord will kindly make it at 4. My lord will allow us to come back because we have
4:15.
I am grateful, my lord. Because then, my lord, then we'll have that 15 minutes.
So I have taken a mean. I have taken an average. 4:30,
My lord, I am
4:15 is
grateful because, my lord, I would not have mentioned because I have suffered this, my lord, in many matters, my lord.
let the matter be listed.